everyone. It's great to be here tonight. So you've heard about give wills and testamentary trust wills from Margaret. I'm touching on life estates. So within your will structure, you can also give a life estate. So we have an example on the slide here where there would be a husband and wife, and we commonly see this arise, or the question of a life estate interest arise where there's a blended family. So take our picture on the slide, for instance, and say we've got a husband and wife and they're of a second marriage, and the husband has children of the first marriage. And the husband's wanting to provide for the wife a roof over her head. So says to the wife, I will give you the right to remain in my property and live in my property for as long as you are alive. But when you pass away, the benefit of that property, or the value of that property, will actually pass to the beneficiary set out in my will. So that's what's known as a life estate, and these can be drafted in any way that the will maker wants them drafted. And I say that because they can be flexible in that it provides maybe a downsizing for the wife, and maybe she doesn't want the house as big as, you know, she can't maintain a big house, so she wants to downsize to a smaller house. And so a life estate can follow what the surviving wife needs. However, they can also be very restrictive in that they can just be a right to reside in one particular property, and nothing can be done to change that gift. And that's all that the surviving spouse receives. These are utilised in, I would say, very specific cases or very specific situations, and we often don't use these for our clients unless their situation calls for it, because what it really does is it ties up the asset, and it also restricts the surviving spouse from being able to do anything outside of this life estate, so very restrictive. And then also it can cause conflicts between the children of the first marriage and the wife of the second marriage. And we're just trying to also avoid conflicts when we're looking at our estate planning. So we say that a life estate is like handcuffing the surviving spouse and throwing away the key. So they are really utilised in very specific situations, and they can also be set out within a give will structure and within a testamentary trust will structure as well. So these can be separate, but they can also be drafted in a way that they are also in the other kinds of structures that Margaret's spoken about. So the other thing to consider with, very quickly on life estates is who pays for the maintenance of the property. And that's something that the will maker will need to decide when looking at the terms of the life estate. So moving on to we've captured the three kinds of wills a person can make: a give will, a testamentary trust will, and then the life estate interest. Now, the will has been created and somebody has passed away. There are two ways somebody can challenge a will. So we've called it challenging a will or contesting a will. So firstly, under challenging a will, the kinds of applications we see in estate litigation are on the basis of these four main categories. So firstly, that the will maker lacked capacity. You only can draft a will if you have the capacity to do so. So if you do not have the capacity, that will could be invalid. Things like a medical condition could cause someone to have a lack of capacity. The other issue is that at law, we say when you're drafting a will or when you're signing a will, you need to know and approve the contents of your will. So that means you need to know what assets you have in order to give away the assets to the beneficiaries that you want to give your estate to. So you need to understand what your estate involves, the kinds of claimants that can make a claim on your estate. So you need to understand, you know, if you're giving everything to one child and you have two children, that can be a very risky decision for the estate because that other child could make a claim. So you need to know and approve the contents of your will. So that's another way that somebody, a beneficiary who's been left out of a will, could challenge that will. The other issue that arises that we see is undue influence. So, you know, that's the situation where we've got a child, let's just say there's a lovely mum who's, you know, at the end of her life, and there's one child who's come along and is, you know, in the ear of mum saying, you know, oh, mum, I'm your favourite, and the other child, the black sheep of the family, is never here to help you, and I'm the one that cares for you, and I love you, and you need to leave everything to me. And there's some sort of coercion that the beneficiary has placed upon the will maker in order for that will maker to distribute the estate mainly to that beneficiary. That's what is usually known as unduly influencing the will maker to distribute their estate in a particular way. If there's evidence enough to be proved in court of undue influence, that will can also be overturned. And then the last two categories are the fraud or forgery kind of categories, which aren't as commonly litigated because the evidentiary requirements are much harder to prove in this category. And the slight difference between fraud and forgery is fraud is usually where the will maker is the one to still be signing a document, they're still thinking they're signing something, but they've been convinced by somebody else that they're signing a particular thing when that is not the case. So there's some sort of fraud that's been placed. It's usually, again, a beneficiary saying, you know, oh, this is just, you know, some document I need you to sign, but it's actually a will. It's those kinds of cases that come under fraud. Forgery, on the other hand, is where somebody has literally forged your signature. And the forgery, you need expert evidence to show that that signature has actually been forged in order to invalidate the will. So when we're challenging a will, you'll see on what I've just gone through, that's the validity of the will. And what kind of results do you receive from a court if you achieve a claim under these categories? Well, the court will deem that will to be invalid. And so if there's a prior valid will, the distribution of the estate will go pursuant to the prior valid will. If there's no prior valid will, then there is no will, and the distribution of the estate will go through under intestacy laws, which I'll get to in a minute. But that covers the basics under claims when you're challenging a will. The other way that you can make an application to the court in regards to a will is under contesting a will. And they're your family provision claims. And Margaret's mentioned the kinds of people that can make a claim on your estate. Those are the eligible people, and they're the only people that can make a claim on your estate. And they have to show the court that they have need if they're going to succeed in contesting a will in order to redistribute wealth. So it actually changes the terms of the will, and it's at the court's discretion how the will be distributed based on the evidence provided by the applicant. And the applicant it has to be an eligible person. There are also another category of contesting a will, and that's your equitable claims, where the will maker has made certain promises. Don't worry, I'll look after you, or you'll be paid, or something along the lines where maybe the child's been caring for them and the parent makes them promises verbally. Those would come under your equitable claims. And again, from an evidentiary point of view, you need to ensure if you're thinking about making a claim in that category, that you have enough evidence to prove that those promises were made. So if we just go to the next slide. So we've done a table for you all to look at in your own time to see there are slight differences between the jurisdiction depending on where the deceased has passed away or where majority of the assets of the deceased are. So generally speaking, and Margaret's touched on this earlier, eligible people include spouses, de facto partners, domestic partner in Victoria and Queensland, which is a de facto partner, children, adopted children, stepchildren, former spouses. So you could have multiple claimants on your estate. And I think we have a slide 2 here, because there are so many people that actually can make a claim on your estate. former domestic partners, grandchildren, members of the household. I know I'm doing a bit of a repeat, but it's really important to be very aware that these are the kinds of people that can make a claim. And if they can make a claim, some of them, if they're in need, they will make the claim. Sometimes people will make the claim not intending to go to a full hearing, but just to get something. So they want to actually get to the point of mediating and settling the matter with maybe just their legal costs. Maybe they'll settle for $100,000. So you can look at the sections of the different legislations in your own time. The take-home point is when you're drafting a will, being aware of the kinds of people that can make a claim on your estate, and drafting a will in a way where you're avoiding those situations if you're happy with those arrangements, and knowing how to structure your will to ensure that the claimants are provided for in the way they should be, what the courts are looking at. So I think we're on to, okay, so how are we able to protect the estate from these claimants? Well, in New South Wales, we do have an ability to be able to release our right to make a claim. So the list of eligible people, they would be saying to the court, I release my right to make a claim on the estate. And we have that under Section 95 of the Succession Act. No other state has that provision or ability. So when you're in Victoria or Queensland, for instance, there is a lot of commentary at the moment, recommendations for change, for law reform in this area. So I guess that's a watch this space, because we could be having similar provisions that we have here in New South Wales come to other jurisdictions. But at the moment, those states, Victoria and Queensland, what we've put on the slides here, you cannot actually go to court, get an order saying that you are releasing your right to make a claim on your estate. So in New South Wales, you can get some full protection by getting a Section 95 order, a release from the court, but not in the other states. Another way that you can protect your assets is entering into, on the next slide, binding financial agreement. So you may, commonly these are often called prenup agreements, or very Americanized versions of prenups. Here in Australia, we call them binding financial agreements. Financial agreement, they're also known as. You can enter into these agreements at any time in your relationship, before, during, or after a relationship. And what this document does, it sets out what you and your partner want to do with the assets when you separate. So these documents only work and they're only binding if you do them correctly. And by doing them correctly, I mean you need to fully disclose all your assets to each other in these documents. So you can't just pick and choose what assets you're disclosing to your loved one. It's all your cards are there. If you don't do full disclosure, the financial agreement, it won't be binding. A court will not uphold that document as a binding financial agreement. The other issue that arises with ensuring that you're drafting these documents properly is in relation to, so we've got full disclosure, but we've got to ensure that both parties are entering this agreement freely and voluntarily, that there's no duress to enter a financial agreement. So if you're thinking about entering a financial agreement, don't do it 2 days before the wedding. Ensure that you get that proper advice to know that both sides are getting independent advice on the financial agreement, and all your disclosures are put forward. And then whatever agreement you and your partner come up with, you would set that out in the financial agreement. So that's another way that you can protect from a claim as well. So it's your Section 95 in New South Wales, or it's your binding financial agreement as another option as well. And then the next slide. So we touched a little bit, Margaret touched on not having a will and the issues around not having a will. But if you do die without a will, you die, it's called intestacy. So an intestate person is a person who dies without a will, or leaves a will but doesn't actually dispose of anything effectively. So you just die without a will, and we call that an intestate estate. So if you die without a will, every jurisdiction has the provision of the order of priority which persons are entitled to your estate, depending on the order of priority, and that order of priority is set out in the legislation. So you can't change that order, you're stuck with it. No will, you're stuck with the intestacy laws. And so if you look at the table on the slide here, you will see the order of priority, and we've listed it from 1 to 8 there because it is in priority. And in just for instance, in number 1, the person who's going to receive your entire estate will be your spouse, widow, domestic partner, or a registered caring partner in Victoria. Then if there's nobody in that category, it will go on to children. No one in that category, it will go on to parents, and so forth. You get the picture all the way down to if there is nobody, it goes to the state. The issue, there's a lot of issues that arise in intestacy. You don't get to choose who your executor is, so you have to actually apply for administration. Somebody has to put their hand up to say, I want to administer the estate. So you have that problem, but you also have a problem, for instance, in item 1, you can have multiple spouses. So somebody could be married, separated but not divorced, so they still have a legal spouse, but also currently in a de facto relationship. What happens then? So in New South Wales, the intestacy laws say if the 2 spouses, because we have a spouse and a de facto partner, have to come to an agreement as to who gets what. Well, you can imagine that would hardly ever happen, that these 2 people are going to make an agreement. So if there's no agreement, they have to go to court, and it's at the court's discretion who gets what. So those are the kinds of traps and pitfalls of dying without a will. And I think tonight you've heard all of us describe things to you that are really to protect your estate. You're building this wealth. You're wanting to ensure that the wealth is going to all of the beneficiaries that you want to select, and doing it in a way that you have the most protection and the most tax minimization as well. So I think, I'm not sure, Tim, do you want to sign off for everybody?
Thank you.
I wanted to, if you guys are finished, I just wanted to ask a few things just to round out the discussion. So I'll wait. Are you guys pretty much?
Yes.
Yes.
Thank you, Adrian.
So on behalf of Superior Accounting Group and all our clients, and also people that we potentially work with, I'd like to thank Margaret, Tim and Claire for their presentation, because I do quite a few presentations, so I know how much time and effort goes into preparing all this. So I very much thank all of you for putting the hard work in and the hard yards to put it all together. There's a lot of really good content, which is going to be very beneficial to most people. And as I say, when I run events, what's important is there's a lot of stuff and it's pretty full on, but the beauty of it is everyone's going to get a tape of this, the YouTube recording of the webinar, the presentation and the conversations. Take your time and go through it at your leisure and digest it all, because there's a lot of stuff here. There'll be elements that'll mean more to you than others, and et cetera, et cetera. So it's really important to digest this at your leisure. And if you have any additional questions, please feel free to contact Margaret, Tim or Claire, or even shoot an email to us at Superior Accounting Group, and we'll get things sorted. What I did want to though is I'm going to talk about a couple of things. As an accountant who works with a lot of small businesses, I would say, because I consider myself a very practical accountant, I would say, and this is not without a lie, and I'm sure you guys have probably backed these stats up, out of every new business owner I work with, I would say it's about 95 to 99% of these people either don't have wills, the wills are 10 years old, they've had kids since, they've remarried, you know, it's basically what they've got is toilet paper or non-existent. And it's that high that it's scary actually. And when I talk to a lot of people, I say to them, it's great to run your business and you know, buy your rental properties and your shares and whatever else you do to build your wealth for your family. But they often neglect what I call the two downsides. One is to have the appropriate insurance in place. you know, your life insurance, income protection, trauma and TPD, PI, all that sort of stuff. But also the wills and powers of attorney and everything else that comes with it. The two, I would say, non-sexy parts of running a business, or the bits that mean people just don't get caught into, they don't think about the ramifications of the downside to who's left. So if you're incapacitated or whatever, and you don't have the right insurances or the right wills in place, the people who pay for that is the people that are left, or the people that are trying to manage and run everything or deal with your estate. So I would say, as I said, it's pretty scary, the percentage of people who don't have them, or they're not really up to date. So I implore everyone to seriously consider the ramifications of not only the right insurance and the right level of insurance, but even more so, because that's what tonight's presentation is on, wills, powers of attorney, etc. Please give it the time of day that it needs. Do it properly. And I'll ask a question about revisiting all that in a minute, because that's the other element that I wanted to bring up. To round out the discussion, I wanted to just cover on a couple of practical elements. So please give it the time of day. Secondly, as a business owner, having gone through this process now twice, I think it's twice, might be 3 times, it's a bigger job the first time you do it, and each time you revisit it, it's not that as big a job to get it adjusted on the run, so to speak. It's a lot of work up front, but it is very important work and needs to be given the time and credit that it deserves and needs for the family. Having been through it, I've done a lot of what, obviously the beauty of this is it's tailored to everyone's unique situation for your business, your family, your extended family, etc. There's no two the same. Everything is totally different. So that's the important part about this. Get your situation reviewed thoroughly, and then put in place what's appropriate to you and your family and your business, because everyone's going to be different. And not only do that, but also regularly review it, because I know I've been through a lot of this myself with you guys. And as I said, it's probably about 2 or 3 times now. But I'm so glad. I sleep better at night. I often call things a sleep at night factor. I do sleep better at night knowing I've got the right insurance and the right wills, powers of attorney in place, so that I know the downside of things is covered. And I think that's really important. So that's the general discussion. Now, a couple of questions for you guys. Can you handle clients in every state, or are you only on the eastern seaboard? What sort of clients can you work with? Is there states you can't work with? Because I know in some issues, state-based things are different and all that sort of stuff with you.
Adrian, we've done estate planning for people around the country in all states.
Okay. Good. That's good to know. Next question, which is what I alluded to a few minutes ago. What's your recommendation for review? Like, in other words, get it set up once, but how do you work? How do you advise people on reviewing all this?
So you don't actually have to review it every 2 years, as sometimes you hear said. Our advice is to, when you do it the first time, do it properly. And then obviously if you want to change your beneficiaries, you should review it. If there have been changes in your trust deed or the trust laws or superannuation, it's appropriate to review it. But generally a lot of people don't review their estate planning if it's done thoroughly and properly at the beginning and there's no changes. If their lifestyle changes, if their lives change, it's probably a good idea to pick up the phone and ask the question, this has happened, do I need to change? That's all it takes, a 5-minute call. And if it doesn't need to be reviewed, we'll say so. And if it does, we'll say so. So it really is just if there are significant changes in circumstances, it warrants a phone call.
And for instance, just talking about our own personal situation, the reason we reviewed and slightly altered what we were doing was a few different reasons, and they were kind of all entwined in each other. One was the executor. We wanted to tweak our executor, because what a lot of people don't realise is executorship is not glory. There's a lot of work involved. So you want to make sure you choose the right person as well, because there's a hell of a lot of time and effort involved as well. Now, I'm not saying this is the right thing to do, but what we've done in our situation, because this is, remember, a personal thing unique to us, we decided with our will to pay our executors a certain amount of money each year, CPI indexed, so that at least if they have to take time away from their busy jobs and lives and everything else, they were at least financially rewarded for the work that was involved. That doesn't mean that everyone has to do that, but I'm just saying there's lots of different options here. One of the options we chose was to reward our executors with an after-tax CPI indexed salary for the work that I know they have to put in. The second thing we did is, because when we first made our wills, the kids were both minors. Scary as it is, Margaret, our kids are now both over 18, which is pretty scary stuff, because how long ago we started all this, right? That's how quick time goes. But when we first did our wills, we had a certain age in our will that we wanted the kids that then, would be held in trust for them until a certain age. We made a decision to increase that age because we thought that the age we chose originally, probably, even though they're both girls, and without being sexist, the girls are generally a bit more mature than the guys, we still thought it was worth increasing it a little bit just to give them that extra couple of years before they would manage it themselves without being in trust. And the other thing was, because our kids were minors, and I can certainly say firsthand as a business owner and an accountant, the testamentary trusts are brilliant for the minors and what benefits you potentially get. No one wants to lose their parent or parents while they're under 18, because that'd be horrible. But at least if that is the case, there is some benefit that they don't get punished for it, like Margaret mentioned earlier. But what we also decided to do is we changed it a couple of times, because who we had down to look after the kids, be guardians for the kids, those situations changed too. So we had to tweak that stuff, because that's a common thing that can change as well. Because the guardians of the kids is a very responsible thing as well, especially when they're minors. So we tweaked that a couple of times throughout our journey with all this. But what we also chose to do was financially reward our guardians too. If they were left and we weren't here, like if my wife and I weren't here, we chose in our will to pay our guardians a certain salary after tax, CPI indexed as well, because we didn't want them to be punished potentially for agreeing to look after our kids and then have to the additional work of trying to run them around to their sporting events and school and take time out of their jobs and businesses. So once again, it's just another option. There's so many options with all this. And I think what people won't realise is they probably won't have thought of those options until they've really explored them, because it was only when we first started speaking to Margaret all these years ago that all this stuff got put on the table, so to speak, and we explored it all and worked out what we were comfortable with. And we thought, well, you know what? We thought that was brilliant to cover off on both sides of this, so that at least the other people who were helping the kids and the family also got rewarded and for the time that we knew they were going to have to put in. And I think that is a brilliant option. And the only other thing we tweaked through all this was, depending on relationships and things, who you want to potentially leave your estate to can also change. So that's the other thing we tweaked over time, because relationships change, family, friends, etc., etc. So I think that's what Margaret was alluding to. The combination of all those things is why we've tweaked ourselves, I think, about 3 times now. But all the work is really in the first one. It's not hard to change it after you do the first one, but it's certainly worth it. I hope that, like insurance, I summarise and say, you don't want it, but if it happens, you need it. And that's like that's why I put insurance and wills in the same category, because at the end of the day, it's downside protection on things going wrong. So I think it's really important that you want your insurance and your wills and powers of attorney and all the rest of it there if you absolutely need it. God forbid, who knows? It's all out of our control, right? So the only other thing I wanted to ask you guys is, for all those people out there who might be thinking, it sounds great, complex, but worth considering. How do you guys handle potential people to work with you guys? Do you have an initial no obligation, no cost consultation where you just throw it all on the table a little bit and explore? How does it work? Because I think that's what people will be thinking about is, okay, this sounds wonderful, but how does it kind of work if we want to move forward, and how does it structure with you guys in that respect?
So we have an initial no obligation consultation where we go through the person's situation thoroughly and the issues, and explore everything. And by the end of the meeting, we'll be able to give a recommendation and also a cost estimate for the suggested work.
Cool. That sounds good.
And just to add to that as well, from a cost perspective, generally speaking, most of the time, and by most of the time, I mean 99% of the time, in terms of our costing, when it comes to estate planning work, it is all mostly done on a fixed fee basis, so that there is full transparency and certainty as to what it's going to cost to complete and prepare all the documents, and actually attend to the execution and explanation of all the documents as part of this process. And it's all done on a fixed fee basis, so you know upfront exactly what it's going to cost to get everything completed in one go.
And you guys, because I know from our experience, you also have a safe custody of will option, so that if people are concerned about where to keep their originals and all that sort of gear, what you guys offer, I know, is to keep the original with you and send a certified version back to the original people, so they've got something that they can use, leave for their, executors, etc. But the original can potentially be housed by you guys, and in some cases, depending on all the situation, even administered.
Yes.
That's correct.
Yes, that is correct, Adrian. We have safe custody facilities at no charge, and we're happy to hold people's documents and wills, etc. For as long as they wish. The other thing, Adrian, is that we also offer a free debriefing session to the beneficiaries and executors of the estate, which can be taken up at any time. And
Yep.
so we have people sometimes who take up that option straight after doing the paperwork, and sometimes it can be years before they call us up and say, I want to take up my debriefing session now. My children are old enough now, and I want to have a chat with them. And we do this Australia-wide, and we can do it by Zoom, we can do it personally. So we're very flexible.
And how, just one final thing, that initial potential, consult potential working with, roughly how long do people need to allow for that consult?
So that will be at least 1 hour.
But I bet you it goes longer than that.
And it will often go to 2. Yeah, it'll be between 1 and 2 hours. Yeah, and sometimes it needs to be broken up into a couple of parts if we don't finish everything in the first one. So people should allow about 2 hours.
Okay.
And I might just add, as part of our process as well, and as part of our service, when preparing, for example, documents such as your enduring power of attorney or a guardianship appointment document, the guardians or attorneys being appointed in those documents as part of our service, we also take those people who are appointed through the documents and have them sign their consents, so acceptance of their appointment to act as our clients or the principal or appointer of that guardian or attorney. We take the guardian and attorney through the document and have them sign their consents, and we act as the certified witness, and there is no additional charge for that service as well.
Cool. Look, and Margaret, Tim and Claire, thank you for all your hard work putting this all together and sharing your copious knowledge, which I know firsthand, having dealt with you guys for probably over 10 years now. And I know
maybe longer than that, Adrian. I think we probably go back, 15, 20 years?
That's Margaret, saying that makes me feel really old.
No. It feels great, Adrian.
And
thank you so much.
I've helped a lot of our clients out too. So I can't speak highly enough of you guys and your knowledge and expertise and what you bring to the table. And just to finalise, what we're going to be doing is we'll be sending out a full copy video of this with the slides as well in the next couple of days. So keep your eye out for that, and please watch that with your partner, because it's important that you both get your head around this, not just one person, because there's a lot involved. And I think that you guys both need to put your heads together. It's a joint thing for sure. not just one person. Yeah, one person might drive it, like in most relationships, but it's really important that both of you get heavily involved with this from day one. So thank you to all of you. I appreciate your time, and I'll let you get back to your families and your busy lives too. So thank you enormously.
Thank you, Adrian. Thank you for
Thank
the
you very much,
opportunity.
Adrian.
Thank you very much.
Thank you.
Good evening, everybody. Bye.